understand, we are just about to enter the room to go and start our mooting. This is our mooting competition starting today, since we joined Brunel University. This must be fascinating. We can't wait.
If it may please your Lordship, my name is Mr. Ahmed, and I appear on behalf of the appellant, Mr. Anderson, in this case. I am ably assisted by Mr. Shah, my junior counsel, who will be assisting your Lordship on the second point of appeal. My learned friends opposite, Mr. Zinda and Miss Katharina, appear for the respondent, Mr. Collins. Would your Lordships benefit from a brief summary of the case facts?
No, please proceed.
The use of the weed killer was a non-natural use of the land. In furtherance of my appeal, I will be relying upon two major authorities. Firstly, Cambridge Water Company against Eastern Counties Leather Public Limited Company, which was cited in the Appeals Court, volume number 2, in the year 1994. I will also be using the case of Transco Public Limited Company against Stockport Metropolitan Borough Council, which was cited in the Appeals Court in the year 2004. If I may proceed with the first authority, my
Yes.
The case of Cambridge Water Company is one of great interest to this instant appeal. The case itself involved the storage of chemicals on an industrial plant. The storage of chemicals on an industrial plant, one would feel, is entirely normal and happens on a day-to-day routine. On this occasion, it was held to be a non-natural use. And the reasoning behind the judgment is of great concern to ourselves as well. And it did so. I refer your attention to the judgment of Lord Gough. He quotes, "Substantial quantities of chemicals in an industrial estate is a classic example of a non-natural use of land." The word substantial is of paramount importance. It was that quantity that resulted in a non-natural use. Similarly, in the present case, the likes of Mr. Collins spray weed killers up and down this country, and never before has a case come to this house. However, on this present occasion, Mr. Collins sprayed it liberally, to use the words of the case, liberally. Therefore, he sprayed it excessively on the garden, and he did so with a very dangerous weed killer in a domestic context. I mean, these weed killers, one would assume, are normally done on an agricultural basis, not in a domestic home. Therefore, my lord, it is neither natural nor is it normal to use such a strong weed killer in the context of a domestic home. Moreover, it is absurd and damaging and dangerous to use such a weed killer on such a scale that it has the effect of going into the neighbour's garden. One would obviously raise grave concerns if this was to take place.
What was the cause?
The cause was actually rain, but I mean, even if you say it was rain, he must have sprayed a considerable amount for the rain to take it from one garden to the next garden, then to poison the lettuce, which was subsequently eaten by a human being, and as a result was admitted to hospital.
Was it a heavy rain?
Heavy rain, I mean, I think that's regardless whether it was heavy rain or not.
Well, it could be act of God.
I don't see how not this present appeal concerns with the non-natural use. We are not discussing escape.
We need to see what is the reason.
Of course, my lord. But I think the fact is, regardless if it was heavy or not, the fact that it did go into the neighbour's garden clearly shows that he must have used it to some great degree. That it had the impact of going into another's property and then damaging his plants. If I may go to my second authority.
Yeah, sure.
My learned friend, senior counsel for the respondent, may seek to persuade your lordship that the use of the weed killer was a natural use of the land, and he may do so in reliance upon the case of Transco Public Limited Company. However, that case can be distinguished from the instant appeal. Firstly, in the case of Transco, it was entirely normal to have such a pipe which caters for 66 dwellings for the water to go through. However, in the present case, it's not normal, neither is it natural, to use such a weed killer, such a dangerous weed killer, in the context of a domestic home. Therefore, it can be distinguished from the case of Transco. Furthermore, I would also like to refer your attention to the words of Lord Bingham in the judgment of that case. An occupier may claim damages if he shows another occupier used dangerous things in extraordinary and unusual circumstances. My lord, the weed killer was all three. It was dangerous, as was clear from the packaging. It was extraordinary to use it on such a scale. And if we both agree that it was dangerous and extraordinary, then it becomes an unusual set of circumstances. In conclusion, it's my submission that for the reasons I have given, the weed killer was a non-natural use of the land. My junior counsel will now assist your lordship on the second point of appeal. Unless I can be of any further assistance, this concludes my submission.
Okay, next. Yeah, sure.
While flexure can be used to obtain damages for personal injury, The Cambridge water case gave it a new dimension by bringing in the element of foreseeability.
Is personal damage recoverable under Ryan Fletcher?
My Lord, from my research, I don't see any logical reason why it shouldn't be, because I haven't come across any law stating explicitly that it can't be. In the light of authorities presented, I would invite your Lordship to overrule the judgment in the Court of Appeal and find in favor of appellants.
Thank you. In response to my learned new counsel for the appellant, I want to discuss Rowland and Fletcher rule, first of all, and then I'll move on to the Cambridge case, and then to the Transfer case. This was not an act of gold. The rain was not an act of gold.
Was it not? So you think it wasn't?
We believe it was not an act of gold.
Okay, so that's fine.
Because the rain is foreseeable.
So this point is not in dispute anymore.
It's not dispute.
Okay.
We concede on that.
So was it a non-natural use of land or was it not? So do you think in this case?
Well, from the outset, I'll say it was a natural use. Because in Cambridge water case, it was held that chemical solvent in industries, we're not talking about industries here, and you did ask that question rightly, it was non-natural use of the chemical because of the benefit to the local employment. Now, if you look at the use in our case, there is no big benefit for anything. My lords, I want to really point you to the fact that my learned friend there talked about substantial use of chemical. I do not recall seeing that in the fact of the case at hand. I will now pass on to my junior learned friend here who will talk about the second issue in the case. Thank you.
In this case, the rule in Rylance and Fletcher cannot be extended to personal injury, as this would extend into the realm of negligence. And in this case, the appellants have sought to obtain damages for personal injury, which cannot be done according to Transco PLC and Stockport MBC. Therefore, personal injuries cannot be covered by Rylance and Fletcher.
They cannot be covered because personal injuries or personal damages are not recoverable under Rylance and Fletcher, or because the damage was not foreseeable.
It's because it cannot be covered by Rylance and Fletcher. It's being discussed in Transco PLC, and it was found that it cannot cover personal injury, as this would extend too far into the realm of negligence. Thank you.
Yeah.
Thank you, my lord. First of all, I completely agree with senior counsel for the respondent that it was an act of God. I completely agree. There's no need to argue in that mode. And secondly, he speaks about Cambridge. We should not be able to use Cambridge because the case facts are the same. I don't know where he got that rationale from. Seems to a manifest misunderstanding of the way the law works. Just because the case facts aren't identical does not mean you can't use the logic that the judge used. Secondly, you posed a very good question of excessiveness. My lord, with respect, to me, it didn't seem to be neither here nor there, and indirectly actually agreeing that there was excessive use of the weed killer. And then he said, on the case facts, there aren't any suggestions that it was used excessively. The word liberally means using in excessiveness. Furthermore, junior counsel for the respondents has seemed to just said that you should not be able to claim personal damages because this is Rylance and Fletcher. There's been no logic behind it, and in fact she has not given any good reason why we should not be able to claim personal damages. And therefore I would call upon your lordship to broaden the approach of Rylance and Fletcher and include personal harm to be able to claim damages. Furthermore, it was stated by the junior counsel for the respondent that would be going to the realms of negligence just by having personal damage for the defendant. Let me assure her, negligence is a very detailed topic, and just by including personal damages, we would be nowhere close to negligence. And I would suggest that you find in favour of the appellant.